Assalamualaikum to Madam Lily. My name is Mati Syara binti Iskandar Mirza, and now I'm going to talk about the introduction. So, in considering the contract law, the point that an agreement becomes solid when all the parties actually agree and the lawyers refer it as consensus ad idem actually counts. So, contract only hold when the parties involved are ready to consent with the activities dismantling the contract, such as the use of force, manipulation, lying, and fraud. So, lying in Malaysia is a matter of concern, and the entire approval is on shaky grounds. So this is done in the Contract Acts 1950 particularly. So section 17, 18 and 19. So section 18 provides that a statement made honestly and accidentally may be used to lead to a contract. So section 19 goes on stipulate that you could resign such a contract provided that you was fooled. So this only means that once you enter into a business with a lie, it cannot be considered the real business. So in this case study, we will delve into unfolding of this in a fictitious dispute with reference the court cases and the interpretation of the law. So, fact of the case, Zara, 26 years old, is a fitness enthusiast when Aurora Fitness Center Sdn Bhd, which is a chain of luxury gym, approached her as they had recently launched a new outlet in Kuala Lumpur. So, the salesperson of the company, Ethan, convincingly influenced Zara to agree to 1 year membership with charges of 3,500 ringgit. So Ethan claimed that it was an all-female fitness center of Aurora, so equipped with certified physiotherapists and licensed by the Ministry of Health completely. So as a company that she needed women only and medically supervised setting, Zara used to this statement and concluded the contract as soon as possible. So when Zara joined the membership, she was found that there were male members around all through the working hours. So, moreover, all the instruction did not have qualifications in the field of physiotherapy, and the gym has never been licensed by Ministry of Health. So, in this case, was presented to Aurora Fitness when Zara insisted on the termination of the contract and a refund and suggested that on this issue. So her consent was not forced but mere promotional enhancements or the sales periphery, not the misinterpretation of the fact. So now the issue is the overriding legal question will be whether the statement made by the representative of Aurora Fitness Center amount to misinterpretation in accordance with a Contract Act of 1950 in Section 18, where the agreement made between Zara and the representative will be avoidable at the will of Zara under Section 19 Clause 1.
And I'm going to be explaining further regarding the relevant laws applies in this case. The relevant law applies is Section 18 Contract Act 1950, which it defines misrepresentation as: first, a false statement made in good faith; second is a breach of duty without intent to deceive; and the third is causing another to mistake the subject matter. Section 19 in bracket 1 explain about the contract is voidable if consent is caused by misrepresentation. Meanwhile, in section 19 in bracket 2, it explains about the exception, which is if the truth could have been discovered by ordinary diligence. Redgrave versus Heard, 18 and 81, 20 CHD1, and it was proven innocent. Misrepresentation allows rescission even if the truth could be discovered. Meanwhile, in the Tan Chai Chew versus Eastern Mining and Metals Company Limited, 1966 to MLJ 32, agreement voidable if consent caused by innocent misrepresentation. The third case is Derry versus Pig, 18 and 89, 14 appeal case 337, it distinguishes fraudulent from innocent misrepresentation. So these are the supporting case law that applies related to the case. Next is the application. So how does this law applies? Eaton's claims that female-only licensed certified trainers were false statements of fact, not opinions. This induced ZARA's consent satisfying section 18 in bracket A. Though not fraudulent, the misrepresentation was innocent. Under section 19 in bracket 1, ZARA can resign the contract. AURORA's argument that ZARA should have checked the facts is invalid in according to the case of Redgrave versus Hurt, and the duty of truth lies on the representer, not the representee.
A very good day to madam. My name is Farah binti Muhammad Yunus, and now I'm going to be presenting my part, which is remedies. So what are the remedies for this case, ZARA against Aurora Fitness Center? So the first is rescission under section 65 CA 1950. So ZARA can cancel the contract because her consent was affected by misrepresentation. So rescission means both parties return to their original positions, so that Aurora Gym must refund ZARA's 3,500 ringgit Malaysia membership fee. So the second is damages. Damages if a fraud is proven. If Ethan's misrepresentation is found to be fraudulent, so ZARA can claim her damages. So this is supported by the tort of deceit under case Dairy against Pig. So the damages compensates ZARA for any losses caused by the false statements. So the third is consequential losses. ZARA also may claim additional losses to that misrepresentation. For example, costing of joining another gym will cause the original contract will be voided. The conclusion for this case is that the issue was Ethan's misrepresentation affected ZARA's ability to give real informed consent. So under section 18 and 19, Contract Act 1950, the contract becomes voidable at ZARA's choice. So the supporting case laws for this ZARA against Aurora Fitness Center, student number Hart case, is Redgrave against Hurt, Tan Chi Chew, and Dairy against Pig. Strengthen the argument that the misrepresentation invalids consent. So the remedies are ZARA is entitled to rescission and full refund of 3,500 ringgit Malaysia. So the law protects fairness and transparency. No one should be bound by a contract formed based on false or misleading statements. That's all from me, madam. Thank you.